Yes, this is the judgment of the court. The claimant by the general form of complaint dated 8th of November 2023 and filed on the 9th of November 2023, accompanied by statement of fact, witness statement on oath, list of witnesses, list of documents, and photocopies of documents to be tendered in evidence. On the 28th day of April 2023, the claimant's employment was terminated by the defendant. On the 31st day of July 2007, the claimant in this suit was offered a 5-month contract as auto electrician in the technical department of the defendant, with effect from 1st of August 2007. On the 15th of December 2007, the contract was extended by 3 months from 1st January 2008 to 31st day of March 2008. The contract was further extended for another 6 months from 1st of April 2008 to 30th day of September 2008. On the 30th day of September 2008, a substantive contract of employment was offered to the claimant by the defendant as an auto electrician on junior staff grade level JS2 with effect from 1st of October 2008. Sometime in 2008, before confirmation of his appointment, the claimant received a special congratulatory message from the vice chairman of the defendant for his vice chairman of the defendant for his achievement in his work. The claimant's employment with the defendant was confirmed with effect from 1st of April 2009. The confirmation was accompanied by promotion with effect from 1st of July 2010, detailing new grade and salary increment. This was in recognition of claimant's contribution to the defendant's success over the years and commendable professional contribution. Again, in recognition to the claimant's unbroken contribution to the success of the company, the defendant approved his promotion JS1 Step 5 with effect from 1st of September 2018. On the 15th day of February 2018, while on morning shift, his HOD1, Mr. Ihimare of Bole, informed the claimant that the equipment named RSO1 had broken down, but he did not proceed immediately to the said equipment until the acting general manager also called him through his mobile telephone phone, directing him to visit the said equipment. Upon examining the equipment, he discovered that the ECU electrical control unit was faulty. The visit was done with a team of 4 other persons, namely Olumide, Obini, Tunde, and Ehimare, the HOD. An email report was sent to the acting general manager informing him that the fault was from the ECU, and the acting general manager ordered the faulty ECU to be moved to his office, and it was detached and sent to him accordingly. 2 days after, the acting general manager invited the claimant to his office, requesting to know the cause of the fault in the ECU, to which he responded that the input current was indicating, but the output supply to the various panels is not coming on, which means it is caused by the ECU. After about 2 weeks, the acting general manager informed him about the visit of some technicians who were expected to carry out further investigation, and directed the claimant, one Mr. Omini and Olumide, to join the visitors in ensuring that the faulty ECU was fixed. The visiting electrician, through direct wire connection, forcefully started the machine and moved it to the workshop, where it was turned off. Thereafter, all efforts made to restart the faulty machine proved abortive. Upon discovering the state of the machine, the claimant with foreman proceeded to see the human resource manager, who surprisingly issued to the claimant what is headed as final warning, explaining it was management decision with a faulty one. On 9th day of March 2023, the chief security officer with his team visited the HOD office and demanded to know what happened, as the team was informed that the visiting electricians alleged that some members of the technical service department, including the HOD, Mr. Imare, the claimant, and others, swapped the ECU with a faulty one. A search was conducted but could not find the missing ECU. On the 10th of March 2023, a letter was served on the claimant to proceed or leave. However, 2 days of his resumption from the annual leave, he received a text message from the human resource manager inviting him to disciplinary committee. His response was that the invitation was impromptu and he was in Akwa Ibom. After explaining the suddenness of the invitation, the human resource manager asked him to ensure that his telephone was on so that as soon as the committee was ready, she will get back to him on a teleconference. At about 4:04 p.m., the head of the human resource called him through her telephone and informed him that the committee was ready and claimant should be ready to answer some questions, referring to him to provisions of the company's manual, Article 6.3, to which he responded that the manual was not handy. The HR proceeded to ask questions upon his answer. She said he will hear from her. On 20th day of April 2003, HR sent another online message informing claimant that pending investigation, his resumption is hereby put on hold until further directive from the management. On the 28th day of April 2003, the human resource manager sent another online message to the claimant informing him the so-called disciplinary committee had established his poor culture, fit, and constant negative remarks about the dependent, and therefore decided to apply the policy as noted in the dependent's employee manual. After the text message on 28th day of April 2003 that shows the outcome of non-existing disciplinary committee, the HR manager, through her telephone, called the claimant asking him to resign his appointment within 24 hours. But the claimant responded that at 4 p.m. it was late to resign. 3 days after, the chief security officer called him, inviting him to the office, and on getting to the office, the claimant was shown a termination letter, and he proceeded to the office of the human resource manager, who tried to confirm if the claimant had collected the letter of termination. The claimant was issued with upward review of his compensation and benefit in a letter dated 19th day of April 2003. The claimant stated he did not obtain any loan facility from the dependent. He was surprised with deduction made from his salary. The termination of claimant's employment was in breach of terms of the contract of employment as contained in Article 3.3.2a, 3.96.2.2, and 6.3 of Employee Policy Manual of the dependent. The claimant instituted this action to contest validity of termination of his employment. Therefore, he praised the court for the following reliefs. They are: 1, a declaration that the termination of his appointment by the dependent is wrongful, illegal, and unconstitutional. B, a declaration that the claimant is entitled to fair hearing in matters concerning his employment in accordance with the dependent's employment manual policy. C, an order of this honorable court reversing the wrongful termination of claimant's appointment by the dependent. D, an order of this honorable court directing the dependent to pay the claimant all salaries and entitlement from April 2023 till date. E, the sum of 20 million naira being damages for wrongful termination of the claimant's appointment by the dependent. Upon being served with the originating process commencing this case, the dependent on the 24th day of November 2003 filed its statement of defense denying the claimant's claim. The dependent admitted employing the claimant on contract. Thereafter, he was offered substantive employment as an auto electrician. The dependent also admitted issuing letter of special congratulations. The promotion of the claimant was said to be in line with the contract of employment, and it was general promotion not peculiar to the claimant. The dependent stated that the technical team led by Ehemare Obole mismanaged the repair, which caused one red stacker RSO2 to be grounded. Furthermore, the technical team, which claimant is one of them, was incapable of effecting the repair and the dependent was losing his huge revenue. The dependent brought in external technical hands from Port Harcourt at the huge cost to sort out the problem, as the in-house technician team were incapable. The claimant was attached to the external technician on their resumption of duty, but on the first day of resumption, the claimant who drove them to their accommodation started giving negative and damaging remarks about the dependent. The said technicians were surprised and worried and have to report immediately to the acting general manager and the human resource manager. The claimant was issued with final warning on ethical conduct based on the frequent verbal negative remarks about the dependent in accordance with the employee policy manual. On 5th day of March 2003, the claimant had altercation with the hired external technicians who were made a response that one of the breakdown forklift. The claimant was furious at them and uttered very bitter words, saying, who asked them to come when he is around. Also, on the 6th day of March 2003, he repeated the same conduct and tampered with the wire of the machine RS01. Diagnosis by the OEM, original equipment manufacturers, it was discovered that one of the issues submitted by Mr. Emore Obolo did not belong to the machine, indicating that there was a fraudulent practice of swap. The claimant was duly issued with notice of annual leave on the 8th day of November with the repeated infraction, insubordination, and disruption of work by the technical team, including the claimant. An investigation was launched, and all those directly involved in the disruption of the workflow were after being reprimanded by the top management, were asked to embark on compulsory leave. Two lead officers were asked to go first, while the claimant was to follow on the 9th day of March 2023. The claimant was given adequate notice, date of time, and for the disciplinary committee hearing, and not the alleged 2 days of his resumption from leave. The disciplinary committee was made up of 3 members: Mrs. Dorcas Ekon, the Human Resource Manager, Gordon Joseph Anogu, Chief Security Officer, and Fatai Tijani, Compliance Manager. They had the dependent on the teleconference on the 19th day of March 2023. The 3 members of the committee asked various questions to the claimant concerning the claimant's involvement in work disruption and his consistent negative remarks against the dependent. At the end of hearing, committee recommended termination of claimant's employment. During hearing, the claimant repeated derogatory statement against the dependent. The claimant participated and never objected to the hearing. It was at the instance of the claimant that the teleconference was chosen, as the claimant has pleaded that it will be difficult for him to be physically present at the venue, as the venue stated on invitation letter. The claimant's employment was terminated by letter of termination dated 28th day of April 2003, wherein reasons for termination were well stated. Also, based on the dependent policy, the claimant's severance entitlement was clearly stated in the said letter, including details of claimant's said severance entitlement. The claimant signed and collected the said letter, including his entitlement as stated therein. The dependent also paid the claimant 1 month salary in lieu of notice of termination as provided in employee policy manual. For the housing, paid upfront will be deducted on monthly basis from January to December. The termination was done in accordance with the employee policy manual. The claimant was satisfied with the procedure that led to the termination of his employment, and he happily collected his severance entitlement with gratitude. The claimant is not entitled to any relief sought as the claimant is on a voyage to a wonderland, and this suit is a product of afterthought. Reply to the statement of defense. In reply to the statement of defense, the claimant stated that the allegations of ethical conduct and the repeated negative remarks are baseless. The claimant was never, throughout the alleged misconduct, given any warning, and apparently there was no query. According to the claimant, Mr. Ehumare Ebole is not the purchasing officer. He only makes requisition to the general manager, who ensured that the correct equipment was purchased. The road stacker have different ECU, and RSO1 cannot be used for RSO2. There was no act of repeated infraction, insubordination, and disruption of work by the technical team, as no previous warning or reprimand were issued in his termination was based on personal vendetta of the acting general manager, Edward Acton, who had now been proceeded to ask only one question. The disciplinary record was first published and ceremoniously removed from the position for reason of incompetence. The claimant stated that he was not invited to the meeting of any disciplinary committee, save the telephone calls by human resource manager, who merely asked him a sole question. The human resource manager over mentioned to him other members were with her, nor any question proceeded from the said members. The claimant never suggested the teleconference for the disciplinary committee, but the human resource manager chose that procedure probably for her convenience. And on the same day, being the 19th day of April 2023, the claimant rather received a telephone call from the human resource manager claiming that the committee was ready and proceeded to ask only one question. The disciplinary record was published for the first time in the statement of defense during the tendency of this action. The claimant was not satisfied with the procedure of his termination, and that is the reason for this suit. The submissions of the defendant formulated two issues for determination in their final written address, which are: one, whether the termination of claimant's employment was done in accordance with the defendant's employee policy manual, Exhibit C-15. Two, whether the claimant has proved his case for wrongful termination of employment and entitled him to relief short. The argument of counsel has been reproduced in the body of the judgment. I will skip reading the argument. The claimant also, in his final written address, formulated three issues for determination. They are: one, whether or not all or any conduct of the claimant constituted misconduct warranting summary dismissal. Two, B, whether the claimant was entitled to fair hearing and whether employment of the claimant was lawfully terminated, whether claimant is entitled to his claim against the defendant. The argument of the counsel for the defendant on the three issues have been reproduced in the body of the judgment. So I will also skip reading the submissions by counsel. Then an additional there is also a reply on point of law by the defendant filed to the claimant's final written address. The reply to has been captured in the body of the judgment. There is also what additional authorities were filed by counsel for the defendants, wherein he argued that the case presented by the claimant is caught by the provision of Public Officers Protection Act and is therefore statute barred. The defendant counsel filed a reply. I have also captured the argument in the additional authorities and the response by the counsel for the claimant. I now go straight to the decision of the court. I have carefully and painstakingly considered the processes filed, the evidence laid at the trial, the written and oral submissions of counsel for the parties. I shall start by dealing with issue of statute bar raised by counsel for the defendant in the additional authority submitted to the court. The counsel for the defendant has submitted that this case is by virtue of Section 1A of the Cross River State Public Officers Protection Law is statute barred for having been filed out of time allowed by the limitations law. Counsel insisted that the decision of the Supreme Court in the case of Awolom versus Federal University of Technology, Owerri, has overturned the decision in the case of Revenue Mobilization Fiscal Commission versus Johnson, an earlier case of the Supreme Court where Section 2A of the Public Officers Protection Act, which is similar to Section 1A of the Cross River State Public Officers Protection Law, was said not to be applicable to employment contract. Counsel for the claimant in response has argued that the case of Awolom versus Federal University of Technology, Owerri, the parties therein are public officers, while in the case at hand, the parties are not public officers. Let me say that the provisions quoted by counsel for the defendant as Section 1 of the Public Officers Protection Law was not correct. For avoidance of doubt, the correct provisions of the law is hereby reproduced, and it reads, where any action, prosecution, or other proceedings commence against any person for any act done in persons of execution or intended in execution of any law or of any public duty or authority, or in respect of any alleged neglect or default in the execution of any law, any act, law, duty, or authority, the following provisions have effect. A, the action, prosecution, or proceeding shall not lie or be instituted unless it is commenced within 6 months next after the neglect or default of, as complained of, or in the course of continuation of damage or injury within 6 months next after the ceasing thereof. It is clear from the provisions of Section 1A of the Public Officers Protection Law of Cross River State that it requires that an action against public officers to be instituted within 6 months of occurrence of the act complained of, failing which the action will be statute barred. This section created exception where the public officer failed to act in good faith, or act in abuse of office, or act maliciously, or act with no semblance of legal justification. It is, however, correct that where a public officer acts outside the scope of his authority or without a semblance of legal justification, he cannot claim the protection of the provisions of Public Officers Protection Law. It is the duty of the claimant respondent to adduce evidence or fact to establish that the bad faith, lack of semblance of legal justification, etc. The facts to be produced must exist to justify must exist to establish the bad faith, lack of semblance of legal justification. Otherwise, once it is established that the action was instituted outside the statutory period of 6 months, the action time is time barred, and the court will have no jurisdiction to entertain them. See Hassan versus Aliu. Now, the question begging for answer is the claimant in this one in which Section 2A of the Public Officers Protection Act is applicable to? Looking at the provision of Section 1A of the Public Officers Protection Act of Cross River State, it will be correct to say that the section applies to acts and actions of public officers performed in the execution or performance of public duties. The claimant in this case is an individual and not private citizen and not a public officer or in the public service. Likewise, the defendant is an incorporated company under the Companies Allied Matters Act and not a corporation or an entity in which the government of the state has controlling share capital. From the foregoing, it is apparent that both the claimant and the defendant in this case are not public officers. Therefore, the provisions of Section 1A cannot apply to this cannot apply to this suit, as it must be shown that the act or neglect complained of is against a public officer and the act neglect was carried out in the course of current performance of public duty, which is not the case in this case. The case is an employment matter between two private individuals, between a private individual and a company. In the case at hand, it has not been shown that any of the parties is a public officer, and it has not also been shown that the act or neglect complained of was done in the performance of official duties or functions. This means that the provision of Section 1A of the Public Officers Protection Law of Cross River State is not applicable to this suit. Therefore, the submissions of counsel for the defendant is highly misconceived, and same is hereby rejected and discounted. Even if it is applicable, the protection applies only to statutory employment as decided by the apex court in the case of Awolong versus Puto, which counsel heavily relied on in making the submission that this suit is started by. In Uwokoro versus INEC, a recent decision of the Supreme Court has made it clear that Section 2A of the Public Officers Protection Act is applicable in statutory employment. In view of the foregoing provisions of Section 1A of the law is not applicable to this case. Therefore, the objection of counsel failed, and same is hereby refused. Counsel for the claimant on his part has submitted that raising this objection in address is improper, as the rules of court require this kind of objection to first be pleaded before it can be dealt with. Where a simple answer to that is that where an issue of limitation of termination to a suit is raised, it becomes a preliminary issue, thereby touching upon the competence of the court, and not merely only to the action itself, but to the court concerned. That is to say, the party raising the preliminary objection is raising issue of jurisdiction, which is fundamental. And by the law, wherever it is raised at any stage of proceeding, the court is duty bound to determine that issue before proceeding with the case on the merit. That is exactly what I have done in this case. See the case of Hassan versus Ali Supra. Having resolved the preliminary issue, I now turn to the substantive suit. The facts of this case, as highlighted above, are straightforward and not complicated. The claimant served the defendant from 2007 to 2003, when by the Exhibit C-16, the management of the defendant terminated employment of the claimant with effect from 1st of May 2003 due to poor culture fit and consistent negative remarks that affect progress of work in the defendant. The conduct was tagged ethical misconduct, and it is noted as a grave misconduct according to Article According to Article 6.2.4 of the Policy Manual, Exhibit C-15, the termination was said to be after several warnings and a written final warning in this regard. According to the claimant, the issuance of Exhibit C-15 letter of termination did not follow due process, as he was not accorded fair hearing. For the defendant, the termination of claimant's employment followed due process, as it was after the claimant had been issued his final warning, Exhibit C-14. Furthermore, a disciplinary committee was set up which tried the claimant and found him guilty of misconduct. It was also stated that the defendant has also paid the claimant one month salary in lieu of notice. The claimant was also informed of the outstanding upfront loan of 223,984,000 After deduction, the total and final amount payable as claimant accounts was put at the sum of 78,959 naira 25 kobo. The final statement of claims of account was tendered and admitted in evidence as Exhibit DW1A. The counsel for the defendant has submitted that the claimant has in his final written address argued on dismissal instead of termination, that there is a world of difference between dismissal and termination. Counsel for the defendant has argued that the cases cited are relied upon were cases dealing with dismissal, while the case at hand, the case put forward by the claimant was on termination of his employment. Let me say that both dismissal and termination cannot end of cessation of employment relationship. Put differently, in both cases of termination and dismissal, the employment of an employee is brought to an abrupt end, although with varying consequences. While a contract of employment is terminated simpliciter, the employee is accorded privilege of receiving terminal benefits provided for under the terms of the contract of employment thereof. Characteristically, the right to terminate a contract of employment is mutually inclusive, since either party may exercise it at will. Conversely, dismissal of an employee more often than not result in a loss of terminal benefit, and it equally carries an unpleasant opprobrium to the employee. See the case of First Bank of Nigeria PLC versus UMCA. See also Jumbo Petroleum Equalization Fund, Jumbo versus Petroleum Equalization Fund Management Board. It is right that dismissal of an employee by the employer translates into bringing the employment to an end, while under termination of employment, the employee is enabled to receive terminal benefit under the contract of employment. The right to terminate or bring the employment to an end is mutual. In that respect, either party can exercise it. Dismissal, on the other hand, is punitive and dependent on the contract of employment, and which entails a loss of terminal benefit. It also carries unflattering opprobrium to the employee. From the definition of dismissal and termination as shown above, they sometimes may look like the same thing, but they nevertheless differ. In the case at hand, and as the relief clearly demonstrated, the claimant's case is on termination and not dismissal of his employment. This has also been made very clear in Exhibit C16, letter of termination. In the circumstances, the duty I shall perform is to see from the evidence adduced whether the evidence before the court, the claimant has proved entitlement to any of the reliefs being sought. An employment contract is premised on an agreement between a person or a body employer who seeks to retain the services of another employee, effectively putting the employee under their control. Like every contractual relationship, any of the parties can decide to bring the relationship to an end at any time, or it can be brought to an end based on several factors, such as an express agreement of the parties, a fluctuation of time or days. The express agreement entered into by both parties in an employment contract provides the procedure of determining the contract, either by termination or dismissal. However, the law is that the employer has the right to dismiss an employee, whether or not it is provided for in the contract of service. See the case of Simon Anasabe versus Bank of the North. Generally, where a contract of service gives a party a right to terminate a contract by giving a particular length of notice or payment of salary in lieu of notice, and the latter's cost is chosen, the party seeking to put an end to the contract must pay to the other party the salary in lieu of notice at the time of termination of the contract. From Exhibit C16, the letter of termination shows that the claimant in this case was entitled to 1 month's salary in lieu of notice in the event of termination of his contract by the defendant. In Chukuma versus Shell Petroleum Development Company of Nigeria, it was held by the Supreme Court that in circumstances where parties to a contract mutually agree that the conditions for termination of the appointment is the giving of notice or payment of equivalent salary in lieu of notice. The only valid notice to discharge a party from his obligation under the contract is by giving of the appropriate period of notice stipulated or payment on the effective date of the notice or the salary or other purposes covering the period of notice in accordance with the contract of service. See the case of Niger Insurance versus Abed Brothers Limited. It should be stressed at this juncture that the payment of the salaries in lieu of notice should be made immediately the letter of termination is handed to the employee, where the court finds out that the employment was wrongly terminated. He would be entitled to payment of his salary and other entitlement for the period for which the employee should have been given notice of termination as damages for the breach. See the case of Samsung Babatunde Olarewaju versus Afribank Nigeria Limited. See also Maiduguri Flour Mill Limited versus ABBA. The application of this principle was vividly demonstrated by the case of Western Nigerian Development Corporation versus Jimo Abimbola, where Ajebo JSC delivering the judgment of the court after stating the guiding principle had this to say at page 382 of the report. The plaintiff was given a letter of appointment exhibit A, and paragraph 5 of that letter reads as follows: your employment may be terminated by the board or yourself by giving 1 month's notice in writing or by paying 1 month's salary in lieu of notice, except in the case of dismissal for an offense prejudicial to the interest of the board. The plaintiff's appointment was governed by the contract which he entered at the time of appointment. If he had been given 1 month's notice before termination of his employment, he would have had no claim whatever on the corporation, but he was not given notice, and he is entitled to 1 month's salary in lieu of notice. That is all that he can get as damages. See also Francis Adeshogun Kado versus CBN. On the evidence before the court, the claimant was only entitled to all salaries and entitlement up to first day of May 2023, when he was dismissed, when he was terminated, and in addition, a month's salary in lieu of notice. The law is well settled that where a contract of employment is terminable by notice and the employer is not given the requisite notice, what the employee could have earned during the period of the notice is the damages that the employee can get. See IDC versus Ajijola. See also Mobile Oil Nigeria Limited versus Abraham Akim Tosoli. The law as laid down by the Apex Court is quite clear. In a master and servant relationship devoid of statutory labor, as in this case, an employer has the right to dispense with the services of its employee for no reason. However, where reasons was given, the onus is on the employer to justify the reason. The employer is as well empowered to summarily dismiss an employee on ground of misconduct or willful disobedience. However, where the condition of service exists before the employer and the employee, the provisions are binding on them. Any disciplinary measure by way of dismissal or termination must follow the laid down procedure. Failure to do so amount to wrongful dismissal or termination. Therefore, an employee who complains that his employment was wrongly terminated has the onus to place before the court the terms and conditions of the contract of employment and to prove the way and manner those terms were breached by the employer. See the case of UTC Nigeria Limited versus Peters. See also OBD versus Delta Steel Company. Even where no provision has been made in the terms and conditions of service, employer has the right to discipline his employee, and all that is required is for the employer to satisfy the rules of natural justice and fair hearing. That a person likely to be affected directly by the disciplinary procedure must be given adequate notice of the allegation against him to enable him to make representation in his own defense. The complaint against him must not necessarily be drafted in the form of a formal charge. It is sufficient if the complaint as formulated conveys to him the nature of the accusation against him. See Yusuf versus Union Bank. Pawali JSC. See also Ramat Umar Bako versus British Council Nigeria and another. See also Ade versus Action Aid International Foundation. According to the claimant, on 19th day of April 2023, the human resource manager of the dependent sent text message to him, Exhibit C20, that the disciplinary committee of the dependent would like to meet with the claimant on 19th day of April 2023 by 4 p.m. concerning employment issues management has become aware about, which is conduct affecting progress of work in the dependent. Venue is admin conference hall of the dependent. It is glaringly clear from the pleading evidence adduced before the court and the submissions of counsel that the claimant is contesting validity of his termination of appointment. It is settled law that where one is suing for wrongful dismissal or termination from an employment with statutory labor or under the common law, the principle of master and servant, the facts of employment and the terms of conditions of service of same must not only be pleaded but must only be proved by evidence between a dependent and the wrong before a determination of the wrongful nature of the termination or dismissal can be considered by the court. See the case of AG versus Chad Basin Authority, where employee, like in this case, complained that his employment has been wrongfully terminated. He has the onus to first place before the court the terms of the contract of employment, and secondly, to prove in what manner the said terms were breached by the employer. It is not a principle for an employer who is the dependent to the action brought by the employee to prove any of these issues. See Francis Kado versus CD and Supra. See also Iwuchukwu versus Iwizu. In the case at hand, since it is the claimant that is claiming his employment was wrongfully determined, he has the onus to plead and prove conditions of service regarding his contract of employment. See Amadu versus Amode. To succeed, he succeeds or fails upon the terms thereof. As the contract of service is the bedrock upon which the aggrieved employee must found his case, he succeed or fail upon the terms thereof. Therefore, in a written or documented contract of service, the court will not look outside the terms stipulated or agreed therein in deciding the rights and obligations of the parties. The duty of the court is to consider and interpret the terms of the contract. See Western Nigeria Development Corporation versus Abimbola Supra. See also University of Lagos versus Olanyo. In the case at hand, the claimant had pleaded his letter of employment Exhibit C4 and policy manual Exhibit C15. This document Exhibit C4 and Exhibit C5 are the terms and conditions of service governing the employment of the claimant. In this case, put forward before the court, the claimant stated that he was not accorded fair hearing in the process leading to termination of his employment. He is also contending that he was not paid 1 month salary in lieu of notice of termination. The claimant is also of the view that the reason adduced in the letter of termination in the C16 cannot justify termination of his employment. The defendant on his part has averred that the claimant was accorded fair hearing as he was invited to appear before the disciplinary committee, and because he was in his village in Akwa Ibom State, he suggested the disciplinary hearing to be conducted via teleconference. At the hearing, he was questioned by the committee and he answered the questions, at the end of which he was found guilty. The committee recommended to the management termination of his employment. The law as laid down by the apex court is quite clear. In a master and servant relationship devoid of statutory labor, an employer has the right to terminate employment of an employee on grounds for good or bad reasons. But the employer is not bound to give reason for taking such action to terminate employees' employment. But where in this case, he gives a reason Cause for terminating employment, the law imposes on the employer a duty to establish the reason to the satisfaction of the court. In this case, the dependent having given reason of gross misconduct for the claimant's termination has the onus to establish that the dependent indeed is guilty of the alleged misconduct to warrant termination of his employment. The employer, dependent in this case, is duty bound to adhere to the rules of natural justice in the conduct of the investigation and proceeding of the disciplinary committee, culminating in the termination of the claimant's employment. See Shell Petroleum versus Olarewaji, where the conditions of service exist between the employer and the employee. The provisions are binding on them. Any disciplinary measure by way of dismissal termination must be followed. The laid down procedure, failure to do so amount to wrongful termination or dismissal, as the case may be. Therefore, the employee who complains that his employment was wrongfully terminated has the onus to place before the court the terms of the contract, which claimant has done in this case, which is C-15. The claimant in this case had tendered Exhibit C-15 in proof of his case that the appellant failed to comply with the laid down provisions for termination of his employment. It is up at this juncture to produce the relevant provisions of Exhibit C-15, the condition of service, to see if the provisions were violated or not. Article 3 provides the objective of this section is to maintain an effective procedure whereby Human Resource Department is adequately briefed and informed about any employee's case from the company. The company recognizes that either or the employer or employees can sever the relationship as a result of a voluntary or involuntary action. To this end, employee may leave the company's employment in any of the following manners: termination of employment, voluntary resignation, redundancy, compulsory retirement, desertion, death, or summary dismissal. Article 3.1 also provides all resignation, termination, and summary dismissal must be made in writing by whichever party initiating it. Article 3.3 on termination of employment provides that either the company or the employee might terminate the employment by giving the required period of notice to the other party without reason for such termination. Due notice or payment of salary in lieu thereof shall be as follows: junior staff 1 month salary, senior staff 1 month salary, management staff 1 month. The managing director or the vice chairman is required to approve employees' termination of employment. The company will ensure full adherence to the labor laws and will be fair to all the employees. Article 6 on staff discipline in Article 6.13, which provide for grave misconduct, has an item called conduct which causes danger to the lives or safety of persons or which seriously affect the progress of work, which seems to be the article the dependent relied on in terminating the claimant's employment, as shown by Exhibit C-16, the letter of termination. Article 6.23 also provides an employee found guilty of major misconduct will have his appointment terminated, which may be with or without benefit. And Article 6.24 on dismissal provides an employee will be summarily dismissed for grave misconduct, which may be without any benefit. Article 6.3 provides the procedure for the discipline of the employee. It is clear from the above quoted provisions of policy manual that the dependent has unfettered right to terminate claimant's employment. However, for such action to be valid, the dependent is required to ensure there is compliance with the policy manual in the process of discipline that will lead to termination. The policy manual by the Article 3.1 has provided that where the termination of an employee's service is initiated by the company's procedure has to be followed, and the human resource manager will be involved in the process. Article 3.3 provides either the company or employee may terminate the employment by giving the required notice or by providing the required notice to the other party. without reason for such action or payment of salary in lieu thereof. In the case at hand, the notice for termination required is 1 month notice or payment of 1 month salary or payment of 1 month salary in lieu of termination. The termination of employment is required to be approved by the managing director or vice chairman of the dependent. The policy manual also demands that in terminating appointment of the employee, the company will ensure full adherence to the labor law and will be fair to employee. It has been stated elsewhere in this judgment that and is supported also by the policy manual. The dependent can terminate without stated reason for termination. But where reason was given, the onus lies on the dependent to establish or to the satisfaction of the court that reason for termination. See Olatu Bosom versus Maisa Council. See also Aliu versus Unipetrol Nigeria Limited. The reason for giving for termination of claimant's employment is as stated in Exhibit 616, which was said to be poor culture, fit and consistent negative remarks that affect progress of work are ethical misconduct and is noted as a great misconduct according to the section 6.24 of the policy manual, Exhibit C15. In the case of Institute of Health, Ahmad Bello University Hospital Management Board versus Mr. Jumai Anyif, the Supreme Court held as follows. Although it is right that an employer is not obliged to give reason for firing his servant, all the same, it is settled law that where he has prepared a reason, he is obliged to satisfactorily prove the same as the onus is on him in that regard. Otherwise, the termination may constitute a wrongful termination or dismissal without more. I note Article 6.24 of Exhibit C15 Policy Manual deal with summary dismissal of employee for grave misconduct, which may be without benefit. However, in Article 6.13 of the Policy Manual, conduct which causes danger to the life, safety of or progress of work was listed as grave misconduct, attracting punishment of dismissal from service. In the pleadings of the defendant, paragraph 10, 11, 12, and 16 of the statement of defense, it seems to be the abandonment to support the reason given for Exhibit 615 for termination of claimant's employment. As the law stands, the onus is on the defendant to prove the reason for termination to the satisfaction of the court. I have carefully considered these paragraphs of the pleading and the relevant paragraphs in the witness statement on oath. It is clear to me that there is no credible evidence before the court to establish the assertion made by the defendant to prove that the claimants had frequently made negative verbal remarks capable of affecting progress of work. The purported remarks were said to have been uttered by the claimant to the external technicians invited to repair broken down machine, and none of the technician was called to testify to that effect. It is evidence from the pleadings before the court that the information regarding negative verbal remarks affecting progress of works was divulged by the technicians to whom the claimant was said to have uttered those words. And it is the technicians that now inform the human resource manager and the general manager of the said utterances that were said to have been made by the claimant. DW and DW2 are the human resource manager and head of security. They never said they had the negative remarks from the claimant himself. This means that whatever information they were told by the technician, the information is hearsay. The fact that DW2 under cross this fact was corroborated by the evidence of DW2 under cross-examination when he was asked. He said paragraph 6 of his witness statement on oath was information he got showing how claimant portrayed the defendant in this case in bad light. In the circumstances, the evidence on the negative remarks is hearsay and is inadmissible in law. I therefore reject that evidence and come to the conclusion that the defendant has not proved the reasons given for terminating the claimant's employment as per Exhibit C16. The reliance on Exhibit C13, final warning, cannot also help the case of the defendant in that by the Article 6.2 of the disciplinary measure to be taken against an employee of the defendant were stated. However, by the Article 6.21, queries and warnings, verbal and written, are only in respect of minor conduct, not in respect of grave misconduct, as in this case. In the case at hand, the reason for dismissal, for the reason for termination, was categorically under grave misconduct in the condition of service. See Article 6.13. This means reliance on Exhibit C13 will not assist or help the case of the claimant. In view of the foregoing, will not help the case of the defendant. In view of the foregoing, I am convinced by evidence before the court that the evidence in proof of the third utterances is hearsay. The defendant has not proved the reason to the satisfaction of the court. I also, having regard to the reason given for termination, the appropriate thing to do is for defendant to comply with the rules and regulation of the policy manual in terminating claimant's employment. The next issue to be considered is whether from the evidence before the court, the claimant in terminating claimant's employment has followed due process. As alluded earlier, and as shown by the provisions of the policy manual, for an employee of the defendant to have the employment terminated for grave misconduct, the defendant is required to ensure there is no infraction of the provisions of natural justice in carrying out the disciplinary proceeding for purposes of termination of employment. The claimant case is that his right to fair hearing was violated and as according to him, there was no hearing conducted, but the defendant stoutly disagreed with the claimant and insisted that the claimant's fair hearing was not violated as he is aware of the allegation against him, and a hearing was conducted via teleconference, was conducted at the instance of the claimant who was in far away Uyo, Akwa Ibom State. The defendant heavily relied on SBC 20 and DW1B as evidence that there was a compliance with the policy manual SBC 15 in the process that led to the termination of claimant's employment. Fair hearing is not an abstract term that a party can dangle in the justice process, but one which is real and which must be considered in the light of facts and circumstances of the case. A party who alleges that he was denied fair hearing, or that the due process was not followed, must prove specific acts or acts of such denial, and not mere agglomeration of conduct which are merely cosmetics. See the case of Emulsion versus University of Benin. The question of whether there was fair hearing during the disciplinary process leading to termination is so glaringly is so weighty that where the court finds that the employee was not afforded fair hearing, it renders the termination wrongful, entitling the employee to damages. As has been pointed out earlier in this judgment, an employer has the duty to ensure that internal inquiry process of disciplinary committee or investigation of hearing process, which was set up to hear determined allegations against employee and based on which the employee was recommended for termination, was done within the dictate of the policy manual and dictate of the law. The dictate of the law as regard fair hearing is predicated on two main points. Simply put, they are that employee must be given the opportunity to respond to the allegation against him or her and must have the opportunity to face his accusers as the case may be. Also, the person sitting in the investigative panel should not be the same person as his accusers. Where this has not been observed, it cannot be said that employee was afforded or given fair hearing before the termination or dismissal thereof, rendering the termination wrongful. It should also be pointed out that an employee can be given an opportunity to present a case in defense of allegation against him orally or in writing. In the case at hand, Exhibit CW1B was tendered as report of the disciplinary committee submitted after conduct of hearing. That there is no dispute that the claimant did not appear physically before the committee for the conduct of the hearing, as the claimant was in Uyo Akwa Ibom State when Exhibit C2 invitation to appear before the court was extended to him via text message by the human resource manager, who also served in the purported disciplinary committee to try the claimant. There is also no dispute that the invitation extended to claimant to appear before the disciplinary committee was served on him via text message on 19th day of April 2023, the date the purported disciplinary hearing was conducted. See Exhibit C20. The law requires affording the person entitled to fair hearing to be given opportunity to defend himself by being present at the hearing. See NJC versus Yerima and another. See also Military Governor of Rivers State versus Hart versus Military Governor of Rivers State. See also Legal Practitioner Disciplinary Committee versus Pawemi. See also Adigun versus Attorney General of Oyo State. See also Garba University versus University of Maiduguri, where Ofuta JSC stated as follows: "It is my humble view that fair hearing implies much more than hearing the appellant testifying before the disciplinary investigation panel. It implies much more than summoning the appellant before the panel. It implies much more than other staff or students testifying before the panel behind the backs of the appellant. It implies much more than appellant being given the chance to explain their own side of the story." End of quote. The party entitled to fair hearing, apart from knowing what was alleged against him, he should be present when any evidence given in his tendered. He should be present when the evidence against him is tendered, and he should be given a fair opportunity to correct or contradict such evidence. For the party to explain his side of the story, he must be allowed to be present before the committee. He also entitled to give enough time to prepare for his defense. I note there is no provision in the policy manual that allow hearing to be conducted by the teleconference. The policy manual requires a party to be investigated to appear before the committee. The requirement of fair hearing demands giving the party entitled to hearing to be afforded opportunity to prepare for his defense. In the case at hand, it cannot, with all sense of justice and fairness, be said that the claimant who was invited to appear before the committee is to appear on the same day he was invited, the same day he was invited to appear before the committee. It would have been different if the claimant was given at least 24 to 48 hours before the invitation and time to appear before the committee. More particularly when the defendant in his pleading has stated that the claimant or receipt of invitation has stated that it will be difficult for him to be physically present, as the venue stated on the invitation letter that same day invited him to appear before the committee. I am of the view that inviting the claimant in the morning and asking him to appear in the evening of the same day. He was not afforded opportunity to adequately prepare his defense. This clearly amount to breach of his entitlement to natural justice. Article 6.3 stated that at all times, the employee will be given ample opportunity to explain his or her side of the story. No employee shall be subjected to disciplinary action without following the principles of fair hearing. This provision of the policy manual was severely violated and battered by the defendant when the disciplinary committee purportedly claimed to have held hearing and found claimant guilty without giving the claimant adequate opportunity to prepare for his defense. To further cast doubt on the report of the disciplinary committee, Exhibit DW1B, it was not accompanied by the minutes of the sitting showing the details of what transpired, who at the purported hearing, who are the witnesses who testified before the committee, and what kind of evidence they gave before the committee. In the circumstances, it is my finding that there was no hearing at all by the purported committee set up to hear the disciplinary to hear the disciplinary action. By the Article 3.32, approval of termination is to be given by the managing director or the vice chairman of the defendant. However, by the Exhibit C16, it is the management of the defendant that has resolved to terminate the claimant's employment and not the managing director or the vice chairman of the defendant as provided by the policy manual. This is another clear and unequivocal infraction of the policy manual by the defendant. It is to be remembered the policy manual is the terms and conditions of service governing the employment of the employer and the dependent, and it is binding on both parties. None of the parties will be allowed to discard it or violate it and go scot-free. From the pleadings and evidence before me, the claimant stated that he was issued with Exhibit C17 upward repeat of his compensation and benefit, and he did not obtain any loan facility from the dependent. He was surprised at the deductions made from his salary and termination of his employment. In his reaction to the dependent, maintained that on its policy. The claimant's severance entitlement was clearly stated in his letter of termination, including details of claimant's severance entitlement. The claimant signed for and collected the said letter, including his entitlement as stated therein. The defendant insisted it paid claimant 1 month salary in lieu of notice of termination. On denial by the claimant of obtaining loan from the defendant, it was about that the claimant was paid upfront annual house allowance in January 2023, which has to be deducted every month till December. The housing allowance was paid in advance as loan. The claimant was satisfied with the procedure that led to termination, and he aptly collected the severance with gratitude. It is clear from the evidence and attached severance entitlement attached as the DWA, which the claimant detached from the original letter of termination tendered as Exhibit 616. The calculation of the claimant's entitlement made by the defendant amounted to the sum of 302,743 naira 25 kobo, from which the sum of 223,984,000 was deducted from the said claimant entitlement, leaving him with only the sum of 78,759,025 kobo, which was paid to him after this deduction, which according to the defendant, the deduction was in respect of the outstanding housing upfront loan paid to him. I have carefully considered the evidence, the submissions of counsel on the issue. I have also taken note of the conduct of the claimant in detaching the tabulation of severance entitlement that was attached to the letter of termination, which the claimant detached from the original letter of termination. I do not know what the claimant want to achieve by detaching a legitimate calculation made by the dependent attached to his letter of dismissal. The claimant acts of detaching the tabulated severance entitlement and remaining silent on it until the dependent brought it to the attention of the court is a conduct that cannot be explained. And it also goes to show the desperation of the claimant to deceive the court by hiding information at his disposal in his quest to deceive the court in believing that he was paid only a fraction of his salary and nothing more. The claimant's despicable conduct and desperation in trying to hide the documents that will have aided the court in coming to a proper decision in the performance of its function of dispensing justice need much to be desired. The conduct of the claimant in that regard is highly condemnable. It is the law that when an employer brings the contract of employment to an end by terminating it, the employee ceases to be his employee, and his subsisting right also ceases to exist. If any, the only entitlement is for the claimant to make entitlement to terminal benefit as provided in the contract of employment. See Chukuma versus Shell Petroleum. The employee could not, at his own option, keep alive a contract of employment which has been determined by the employer, whether rightly or wrongly. This is because termination or dismissal of employee by the employer, more particularly master-servant relationship, translate into bringing the employment to an end. See ASAN versus NNPC. See also Jimbo versus Petroleum of Collaboration Supra. It is right law that except in employment governed by statute, wherein procedure for employment and discipline, including dismissal of the employee, are clearly set out. Any other employment outside statute is governed by the terms under which the parties agreed to be master and servant. Likewise, in this case, the employment of the claimant is governed by Exhibit C-15. Employment with statutory backing must be terminated in the way and manner prescribed by the statute, and any other manner termination is inconsistent with the statute will be null and void. However, the court cannot hold termination of employment of employee in relationship without statutory labor as null and void and go ahead to award to such a party damages in terms of what would have been earned had the contract of employment subsisted. See UBN versus Ugbo. See also Riba Vegetable Oil Company Limited versus Ebukole. The relationship between the claimant and the defendant is that of master and servant. In the master and servant relationship, a termination of appointment is at variance with the contract of termination appointment that is still takes effect in bringing the employment to an end. The fact that the termination of a servant is otherwise than in accordance with the procedure laid down in the contract of service does not, however, in any case where the rights of the parties are regulated by contract normally prevent termination from being effective. The termination is effective and cannot be disregarded. In such case, the servant remedy is in damages. See UTC Nigeria Limited versus Nwokuruko. See also Kwara Investment Limited versus Garuba. See also Wilbros Nigeria Limited and another versus Macaulay. It is now settled beyond peradventure that in master and servant relationship determination of employment is a matter inconsistent with the terms of employment agreement connotes only wrongful termination of appointment, but not declared such termination null and void. The only remedy a claim for damages for the wrongful dismissal. See the case of Union Bank of Nigeria versus Ugbo. Is also Query versus Golden Guinea Breweries. It is also the law that in master and servant relationship, a termination that is at variance with the contract still takes effect, bringing the employment to an end. The fact that the termination of a servant is otherwise than in accordance with the procedure laid down in his contract of service does not, however, in any case where the rights of the parties are regulated by contract, normally prevent termination from taking effect. The remedy for wrongful is damages, as stated in Ibama versus SPDC. In any event, except in employment governed by statute, wherein procedure is laid down, the dependent will only be liable for wrongful termination to pay damages, which is the amount of money for the period of termination. In this case, it was provided that the period of termination is one month. Therefore, he is only entitled to 1 month salary in lieu of notice. In the light of the foregoing exposition, the position of the law, the claimant is seeking for declaration that termination of his employment by the dependent is wrongful, illegal, and unconstitutional succeed only in part to the extent that the termination of claimant's employment is only wrongful, but not illegal and unconstitutional. Also, having regard to the fact that the purported disciplinary hearing that culminated in recommendation of termination of claimant's employment having not been conducted with the claimant physically present face to face is accused by the accusers, his right to fair hearing has been violated. Therefore, he is entitled to relief B to the extent that he is entitled to be accorded fair hearing in matters concerning his employment in accordance with the dependent's employment policy. For relief C, the law is right. Wrongful termination cannot be reversed. It subsists, notwithstanding being wrongful. In such a situation, the claimant will only entitle the damages for the period of notice. On relief D, in master and servant relationship, once termination took effect, it cannot be reversed, except in exceptional circumstances as recognized by law. And in the case at hand, the claimant has not proved that he fails within the exception. The law is no employee can be paid for work not done. The claimant termination of employment as per Exhibit 16 was with effect from 1st of May 2023. This means that claimant is not entitled to be paid salaries from April 2023 till date of the judgment. What the claimant typically is entitled to is damages for breach of his contract. This was affirmed in the case of CGC Nigeria Limited versus Bakare and another, and where the Court of Appeal held that the instatement is not an available remedy under a contract of employment without statutory labor. Instead, the employee may be entitled to compensation equivalent to notice period or salary in lieu of notice, as stipulated in employment contract. The case of UBN Limited versus Equanwa further illustrates that the court's power to order reinstatement is limited, or to order the continuation of the employment is limited to situation where employment has statutory labor. In the absence of statutory provisions, the court is generally reluctant to impose working relationship where trust and confidence have been eroded due to wrongful termination, while an order reversing wrongful termination is possible in certain circumstances. It is generally not available in master and servant's relationship without statutory labor. Employee in such a relationship should primarily seek damages for breach of contract unless specific contractual or statutory provisions are provided otherwise. Relief E is for damages is claimed for 20 million damages for wrongful termination. Is described that damage is recoverable. A wrongful termination is damages for the period of notice. It is clear from the foregoing that the claimant has only succeeded in proving that termination of his employment was wrongful. He is also entitled to an order directing payment of claimant's salaries. He is also entitled to an order. He is also not entitled to an order directing payment of claimant's salaries from the date of termination till date. It is not an appropriate order to make in this case. As termination was done, it takes effect immediately, and the deprived employee of claim of salaries from the date of termination. The damages for termination is damages for the period of notice. The court does not have power to reverse wrongful termination of the employment. It is now beyond any argument that a master and servant relationship, which is devoid of statutory flavor, as in the instant case, termination of the employment of an employee by the employer cannot be wrongful unless it is in breach of the terms and conditions of contract of employment. It must, however, be always remembered the parties are bound by the terms of the contract voluntarily entered into. Once there is a compliance with the terms of the contract of employment, the termination can never be said to be wrongful. However, where there is written provisions for terminating the contract of employment and the termination is carried out in a manner which is contrary to the terms of agreement between the parties, the employer must pay damages to the breach for the breach of the agreement between the parties. The employee, however, is not entitled to general damages as in the claim in tort. He is only entitled to what he would have entitled to over a period required for lawful termination of his employment. See the case of Garuba versus KIC Limited. In the case at hand, the claimant is only entitled to 1 month salary in lieu of notice as per the policy manual, which he has tendered in evidence. However, Exhibit DW1A, which was tendered by the defendant, clearly shows that there was a tabulation of claimant employment, which included 1 salary in lieu of notice and his salary for the month of April, which the claimant stated that it was, which the defendant claimed it was paid to the defendant, but he was paid only 78,000 because of the deduction of allowance. Let me say here that allowances paid to employees are not deductible from salary. Those allowances are entitlement of the employee. If the defendant decided to pay the said entitlement at once, it cannot, by determining the employment of the claimant, deduct such entitlement from the entitlement of the employee. It is wrong for the defendant in this case to deduct from the entitlement of his employee, having found out that the claimant is only entitled to 1 month salary, and also what he is entitled, he has earned as per his contract. I come to the conclusion that what the claimant is entitled is what the defendant has tabulated is Exhibit DW1. But the defendant is wrong to have deducted 223,000 from the said entitlement. The defendant in this case is hereby ordered to pay the claimant 303,000 naira, which it has admitted or it has tabulated and stated is the true entitlement of the claimant, minus the 78,000 naira deducted from the defendants from the said entitlement, which was paid to the claimant earlier on. That is the order of the court. Before ending this court, I must observe that the conduct of the claimant in this case is detestable, as the claimant tried to not to put all the materials that he is fully aware of. I do not see why, I still cannot fathom why the claimant decided to remove a document that was lawfully attached to his letter of termination, which also gave him information regarding his entitlement. He hid that letter and now came with frivolous request for payment of damages to the tune of 20 million naira. The said claim of 20 million naira is outrageous and is not deserved. The claimant did not deserve to be granted that, and it is dismissed. The only entitlement, as I said, is 1 month salary in lieu of notice and other entitlements, which are as contained in Exhibit DW1A, which was tendered by the defendant in this case. As stated, the claimant is only entitled to the calculation made by the defendant as per Exhibit DW1A minus the 78,000 naira which has earlier been paid to him. That is the judgment of this court.
As my Lord pleases. My Lord, we are very grateful for your erudite judgment.
Yes. Yes. Yes, any other thing?
No, my Lord, we thank you for your erudite judgment.
Okay, you are welcome. You are welcome. What's the next case? Yes?